Good evening to you all and welcome to the lecture series on law of sea and maritime law. Now we are discussing on law of sea and maritime law. This is week 4 and lecture 5. As we are in our previous lecture, we have started discussion on the Indian laws pertaining to the maritime area as well as the maritime jurisdiction, and now we will be discussing also about the Maritime Zone Act. Now the maritime jurisdiction, that was all related to the ships. Now we take the maritime zone which is covered under the Maritime Zone Act. So how it originated? It was in 1976 that the Indian Maritime Zone Act gave the Government of India exclusive jurisdiction to authorize, regulate and control scientific research. Since different laws, they are framed with different objectives. The earlier laws that we were discussing framed by the India were in relation to the ships and the rights of the parties pertaining to its transportation or collusion, like we have discussed in the last lecture. Now here it is the rights the state does have, that is India does have over its exclusive jurisdiction. Those rights that are protected through the Indian Maritime Zone Act. Maritime Zone Act means that includes territorial water and contiguous zone and the exclusive economic zone. That is to authorize, regulate and control scientific research. So mainly why the focus here is more towards exclusive economic zone, because there to that extent India does have the right to do the scientific research, scientific exploration also. It prohibited any person, including a foreign government, from conducting any research within India's exclusive economic zone. I would like to remind that exclusive economic zone is not simply like stating 200 nautical miles, but it starts from the baseline. Like if this is, we are talking about India here, if this is the baseline and let's say this is the southern part of India, the coastal part, and here is the baseline. All right, so from baseline to 200 nautical miles, that is the exclusive economic zone area. That means it covers up till this point, and it includes territorial waters and also it includes the contiguous zone. So it is not excluding the territorial waters and exclusive territorial waters and the contiguous zone, but while defining or determining the extent of exclusive economic zone, we cover also the territorial waters and also the contiguous zone. However, the nature of rights while talking about the territorial waters, while talking about the contiguous zone, they are different than that of the exclusive economic zone. So the issue of allocation has become more prominent by agreement undertaken by the Government of India with South Asian or other neighboring countries. When just we were talking about this maritime zone that is created. Now this is to assert the right up till the exclusive economic zone area. So since India has neighbors also having sharing the sea water like Sri Lanka, Bangladesh, Myanmar, so all that rights that are asserted and claimed by the India need to be keeping in mind the rights of the other states also, for example Sri Lanka, Myanmar and others. Conducting any research within Indian exclusive economic zone except under and in accordance with the terms of an agreement with the Government of India or letter of authority granted by the government. Although India does have exclusive right to do the scientific research, and it prohibits, the rights are to the extent of creating prohibition to any foreign person or any person that includes the foreign government from conducting any research within India's exclusive economic zone, except under and in accordance with the terms of an agreement with the Government of India. But that is not absolute bar. The party that belongs to foreign land or that is part of the foreign government or any such foreign person is maybe for certain reasons willing to do research in the exclusive economic zone area of India. Let's say someone from US university who is doing research in the Indian Ocean or in research on Andaman Nicobar Islands and is willing to do research all across the water area of Andaman Nicobar Islands. So he or she cannot be totally barred. I mean, they can do this subject to the condition that permission is granted by the Indian government. If no such permission is granted, then he cannot do. But he definitely has the right to request the government for such permission. So that is the choice is with the Indian government if it is willing to allow or not. It prohibited any person, including a foreign government, from conducting any research within India's exclusive economic zone, except under and in accordance with the terms of an agreement with the Government of India or a letter of authority granted by the government. Or it can be that Indian government collaborates with that foreign university, foreign person, or any such association or a company. Thus, India provided for consent-based regime for scientific research in its exclusive economic zone in accordance with the views expressed by Uni Clause 3. So, we use the term here that the permission is subject to the approval of the government or subject to the consent given by the Indian government. The issue of allocation has become more prominent by agreements undertaken by the Government of India with South Asian or other neighboring counterparts, because they are the closest neighbor. South Asian region is the countries that are within the South Asian region, they are our closest neighbors. So definitely we cannot ignore if they are willing to do research or they are business activities are also involved in exclusive economic zone, but that is again subject to the permission given by the Indian government or subject to the conditions that are set by the Indian government. Most of the South Asian states are gifted with long coastlines but without any developed maritime capability. Now it's actually most of the South Asian, but not all South Asians are gifted with the coastline. For example, Nepal does not have the coastline, neither Afghanistan does have, so they are completely landlocked states. Therefore, they rely on the Indian waters. So how does the Indian government allow them? That is between the mutual agreement between India and Nepal, India and Afghanistan. And therefore, based on that agreement, they can work here in the Indian waters also. Geographically, Nepal and Bhutan are landlocked states with convenient transit routes only through India since 1947. So the example is given here that there are two such states who are landlocked states, but they have some transit routes through India based on the mutual agreement between Indian side and the Nepalese and the Bhutanese side. Pakistan, India and Bangladesh with sharing land frontiers are of littoral nature, that means the land closer to the water. Sri Lanka, Maldives are islands, however the former has a continental character while the latter, with a chain of 1087 small coral islands, has an archipelagoic nature. Now what is the continental nature? That where it's on one side surrounded by total land area, all right. But what is the archipelagoic nature? Like there are a group of islands, so it is like this, that creates one nation, so that is the chain of islands or small coral islands. The South Asian region is Indo-centric, that means it's not simply that Indian culture is affecting the South Asian region, but geographically also, if we see, it's more like India-centric. And one other aspect that for that reason we also call it the India-centric is the influence of Himalayan river and also the Indian Ocean. So the flora and fauna or the biodiversity that is created, the biodiversity and the marine life, they are similar genetic species. There are variants, but by and large they are of the similar genetic species. Therefore, we state that it is all India-centric. The South Asian region is like that. The South Asian region is India-centric, thus needing a special examination of bilateral relationship between India and South Asian states. In Asia, about 28 maritime boundary agreements have taken place. Out of these, 9 were concluded between India and 7 neighboring countries. So there are different Asian states and they have like settled these issues by mutual agreement or bilateral agreement. Out of these, 9 were concluded between India and 7 neighboring countries. Negotiations between India, Pakistan, India, Bangladesh have not yet reached a conclusive stage. Mainly with regard to India and Bangladesh, most of the issues has been resolved, but with India and Pakistan, the issues are still pending. Mainly the use of ports by India, Chabahar port, and there are certain other ports that the Pakistan has not made its intention clear. So therefore we cannot say, and many a times the contract that are made between Indian government and the Pakistani government, they have been not successfully fulfilled. For that reason, the situation remains in dilemma. Whereas India-Bangladesh situation is very different, and India has favored in that respect Bangladesh because of its geographical condition, because Bangladesh faces a lot of storms, and many of its area is under the sea waters, the coastal area that remains under the sea water. Therefore, the Indian need to consider all the challenges of the Bangladesh state, and therefore India has accepted many kind of concessions being given to the Bangladesh. So other 5 countries have already had agreements in the recent past. So we may say that in South Asia, countries with opposite coast have succeeded in maritime boundary delimitation. Now, the countries in South Asian region, countries with maritime boundary have succeeded in delimitation means like India and Sri Lanka, they have succeeded. So the boundary delimitation between these countries is not strictly based on the unique clause rules, or we can interpret it like this: the unique clause rules have allowed those boundary coastal states or the maritime boundary between those states to be resolved through bilateral negotiations. It's not necessary that they go by any such strict standards that are set by international law or the law of sea, but if something can be sorted out between the parties based on the bilateral agreements, and also considering the historical accounts or the customary practices between the parties, so that has been accepted here. So we may say that in South Asian countries with opposite coast have succeeded in maritime boundary delimitation. However, countries with adjacent or continuous coastlines are facing problem. But as stated, because of certain issues, and mainly those, there are 2 issues that creates conflicting interest. One is when there is illegal immigration through the sea route. Second is if the fishermen, they enters the sea water of the neighboring states without any such permission. So that is another. And then the security concerns. If a neighboring state feels threatened by any such activity of the another neighboring state, and they share the same coastline or they share the same water boundary. So in that respect also the concerns get serious. Now we briefly refer about India-Pakistan maritime boundary. India-Pakistan maritime boundary demarcation in the Arabian Sea between Pakistan and India has not yet reached an agreement, mainly due to the lack of urgency and inherent reluctance to relinquish claim to the seabed area, which may later prove to have commercial potential hydrocarbon deposit, vital in their quest for energy independence and economic security. The coast's curved shape and the agreed baseline selection are major contentions. Why? Reason being because who will take the major part in this case? The coast curve, that means if there is a curve area, so outside like if this is the curve area, and mainly that goes closer to the state of Gujarat. That states closer to the state of Gujarat, so it is here. Then in this area, who will make the larger claim? All this, the curve area. So whether that should go more towards the Pakistani side or the Indian side, that becomes the contention. Similar such contentions are existing when we talk about the settlement between Pakistan and India, and that is because of the hydrocarbon deposit or other minerals that are deposited in these areas, and higher claims are made by both the countries, realizing the fact that they will be economically benefited. Whoever gets succeeded will be more economically benefited. Then is India-Sri Lanka maritime boundary. The negotiations between India and Sri Lanka in 1974 and 76 solved the existing problems by providing Sri Lanka with sovereignty over the islands of Kachchativais in Palk Bay. We have already discussed this. And retaining traditional maritime facilities to the fishermen. It also allowed Sri Lanka to fish on the west bank. Thus, the boundary line between India and Sri Lanka followed the median line principle, except as adjusted in Palk Bay in relation to settlement on question of island of Kachchativais. The agreement further stipulated that if any single geological deposit was found extended across the boundaries of either side, the 2 countries shall seek to reach an agreement as to how structure of the field shall be most effectively exploited and apportioned. So both the parties have decided things amicably, and also for the future concerns they are agreed to resolve it. Then is India and Thailand. Minor adjustment in Andaman Sea between India and Thailand were made to separate India's Nicobar Islands and Thai coasts by a series of median lines with full weight given to these islands, which are presumably India's mainland. So when we talk about the Andaman Nicobar Islands and the Thailand making the minor claims all across that area, so India has accepted partly the Thai claims given to these islands, which are presumably India's mainland. Thailand relied on the reason of simplicity in the administration principle and Thalweg principle of natural prolongation, while India finally compromised through the modification of purely median lines. Thus, the effect given to those faraway Indian island is less than full, yet more than half. So, India has accepted it. Now, here it is mentioned about Thalweg principle. And what is Thalweg principle? It is like if there is the river that falls into sea, but prior to the river falling into the sea, it shares the border with two states or more than two states. So then how we will draw the median line? We will draw actually not the median line, but we will draw the lines through the deepest point of the river. Deepest points of the river. Now the reason for taking the deepest point is because usually the river keep on changing its travel route, and before it falls into the sea or before it merges into the sea. And every time if it is changing its route, every time here means every year, if let's suppose every year it is changing its route, then how we can rely on the median points? That means the median points will keep on deflecting. Therefore, that will not lead to a consistent division between the two different states. So we have to keep in mind that the deepest point that usually do not get changed, even if the river is changing its course, so that can be accepted here for deciding to what extent these countries are using the waters that are divided between through the Thalweg line interpretation. Then is India-Burma. The only possible dispute in boundary demarcation between them may arise over the issue of ownership of Narcondam Island in the Andaman Sea, which Burma sometimes appear to covet from India, its neighbor. Geographically, Narcondam Island is craterless volcano with an area of 7 square kilometer, which stands 710 meters above sea level and is bounded by 100 meters in height. In this case, India insists that any boundary negotiated with Burma gives its full effect to Narcondam Island. It further implicates that the Indian claim will also cover part of the continental shelf of the Irrawaddy River Delta. The fate of the area concerned would finally depend on whether the line of equal distance was based on Burmese coastline or baseline which closes the Gulf of Martaban. Now here you can see where is the Narcondam Island. This is the Narcondam Island, and we were discussing about the Andaman Sea and reference about the India. So you can see about this is the Thailand and all this area which belongs to India. So here there are some islands that gets closer to the Thailand, and Thailand has also been making the claims. So India has accepted those claims despite the fact that the major part of this area belongs to India. But and similarly, India has also accepted the claim made by Myanmar to this Narcondam Islands. This is one such example. You can see here in the next map. This is Thailand. This is Gulf of Thailand, and we were talking about this Thalweg line, and it is this Thalweg line division is mainly, this is Gulf of Martaban. You can see here. We just have discussed between the boundaries between this Myanmar and Thailand. So that is one such area where we need to take into consideration how the boundaries will be divided. So this is the river area from here onwards. All right, that needs to be decided according to the Thalweg line interpretation. In the first case, the area would be 1,175 square nautical miles. In the second, the area measures 580 square nautical miles. On a number of occasions, the Burmese authorities have claimed Narcondam Island, but India has shown a determination to defend its sovereignty in this matter. Burma would presumably argue on the grounds of natural prolongation, no claim to part of continental shelf of Irrawaddy River Delta could be made from Narcondam Island. So this is like both the sides, they have been making their claims to this Narcondam Island. But anyway, the present situation is the use of that island is more with the Burmese site. However, there are two counter arguments against this view. First, Sundara Shelf terminates at a submarine ridge linking the island with continental margin of the delta. Second, the question of natural prolongation need not rise in case where the states are less than 100 nautical miles apart. India could simply make her claim to an exclusive economic zone and refuse to discuss question of continental shelf separately. Reason here is it is natural prolongation means since it is closer to Burma, so it is a natural prolongation of the continental shelf area. What is continental shelf area? Like if there is a hilly area underneath the water, and that there is certain rise above that hilly area like this. So again, there is that the land area or the subsoil area, it goes like this. But this can form an island. So this will be belonging to the closest area. That is the natural interpretation. So that is what it means by the natural prolongation. Now is the maritime law of India. The 1970s saw growth in the movement for many less developed countries to participate in world shipping. And this maritime law covers basically, again, it has adopted mostly the provisions from the English system. The United Nations Conference on Trade and Development produced in 1974 the Convention on Code of Conduct for Liner Conference. Conferences are a group of ship owners who came together to provide a regular cargo service in which there are uniform freight rates and shared sailings. Firstly, we need to understand how the maritime law came into existence on a global basis. Now, how this practice started long time back, it is basically the part of Lex Mercatoria. Lex, Mercatoria. Okay. Now, Lex Mercatoria means law of merchants. Why we connect this with the Lex Mercatoria? Because the traders or the merchants, they have the tendency to sell their goods to far off places or send their goods to far off places for the business purposes. And earlier they were sending their goods to far off places through the land route. But once they realized that the human beings have achieved the level of technology for using sea routes also for the purpose of transportation, so these merchants or these business people, they started using the sea passage for transporting the goods from one part to the another, and that was even more cheaper. Where it get the lead, or where you can say it was beneficial, and till date, the sea route or transportation of the goods through sea route is beneficial, because the heavy goods that cannot be easily transported from one place to another through the land route, and it can be more easily transported through the sea route. All right, except that we take all the precautionary measures for the sea storm or the rough weather in the sea condition. So realizing this fact that the bulk of the goods that can be transported from one place to another through the sea route or through the river navigation, they started developing those ships or bigger ships, and they started exploring the sea routes. Now, after exploring the sea route, they need to have certain customary practices also, because at earlier time, once the ship is on voyage, so that will return maybe after 1 year or maybe after even 2 years. That means if in case something happens to that ship, or in case something happens to the goods that the ship is transporting, it must be protected by certain set of rights or certain set of rules belonging to either this country or to the different coastal countries. And those rights and those rules, they were not at that time enacted by means of legislation, because mainly it was all under the monarchy system. But anyway, the people that were living on those coastal places or at the places near to the port, they definitely realized the importance and the significance of using the sea route. So therefore, they developed customs and practices that were friendly, or let's say that were conducive to the ships that are coming from far off places, that are belonging goods from the far off places. So through that, and even the banks that were at that time, the banks were open close to the port cities, and after those banks were opened, then the court system was also initiated closer to the port cities, so as to give those courts admiralty jurisdiction. Now, why those courts that are closer to the port cities were given this admiralty jurisdiction? For example, let's say there is a famous port, Hamburg, in Germany, or let's say there is a famous port, Visby, or ship has reached to the place Hamburg. But the Supreme Court of Germany lies somewhere in Berlin. And if the dispute arises between the parties that are carrying the goods, or the goods are transported through the ship, that has to be resolved now immediately, or in the swiftest manner, or in the manner where there is a less loss of time. So that means the party will not run to Berlin to get the dispute resolved. So what it will do, that means the king has to realize the practical challenges or the practical difficulties, that the dispute cannot be resolved immediately if they are asked to reach the Berlin. So why not to give the jurisdiction to the courts over that area, special jurisdiction to the court over that area to resolve the dispute. So these circumstances led to the creation of admiralty jurisdiction, and what we see today, and gradually developed and set the rule as maritime law. So that is how the maritime law originated. Basically starting from the customary practices of the merchants, and later on it took the legal shape, and then after legal shape it firstly started with the admiralty courts and the admiralty jurisdiction, and then it framed the complete structure. Based on that complete structure, different set of international conventions were set. So here, when we have talked about the conventions were set, the most important convention is United Nations Conference on Trade and Development. That is the conference dealing with the trade issues. So realizing that the maritime trade, or the use of sea route for the trade purposes, that falls within the part of international trade. So the provisions that are framed with regard to the maritime law, they must be framed keeping in mind the parameters of international trade, and mainly the international trade when it is adopted through the sea route. So in the light of this, the United Nations Conference on Trade and Development produced in 1974 Convention on Code of Conduct for Liner Conference. Liner Conference is those companies that are dealing with the ship or liner industry, like Viking Line, Celia Lines. So these are the liner industries. Because then only we will be able to know what problem these shipping companies are facing when they are going to far off places and doing the business, or they are carrying the goods belonging to one party and they are settling those goods, or they are disembarking or reaching to different places and finally giving the goods to the parties to the far off places. So that means they must be very clear. Those liner companies must be clear about the set of laws, and more importantly, the laws should not be different. So if the journey of a ship starts from, let's say, London port, and now it has to reach to Sri Lanka, so there has to be some set of commonness between the laws, the maritime laws in Sri Lanka, and also the maritime laws, let's say, in London. Then only in case there is a dispute between the parties, one that has, let's say, that is sending the goods, or that has loaded the goods in the London port, and then there is another party which will take those goods, or when the goods will be unloaded, offloaded at the Sri Lankan port. So how, in case there is a damage in between the transit, then how they will resolve? So those laws should be common, or even if there are different laws, they must be based on some common parameters. Therefore, the rights of the parties that are affected, they can make the claim either in the Sri Lankan court, even if the goods were loaded at the London port. So how that harmony can be created? Harmony can be created if by these conferences, international conferences, different parties, they collectively realize this problem and they agree to the common provisions for international trade through sea. Now with this, I am very much thankful to you for being part of this discussion. I thank you for attending the entire course on law of sea and maritime law. I have tried to cover the most important parts that lead to the development and relevance of both the law of sea and maritime law. Although things are taken quite briefly, but I hope this would be at least giving you an overall view of both maritime law and law of sea. In future, it could be that we organize an advanced course. We do record an advanced course on law of sea and maritime law, and there we discussed mainly the maritime law in detail and in more depth. For now, I thank you very much for participating in this course and wish you good luck. Thank you.